presence of this voluntary system is an argument in favor of governmental intervention. It's an argument against, because it shows that this is not something that is narrowly tailored to any actual problem.
It's an argument that shows that maybe it's not so hard to draw classifications for this type of material. That maybe it's not an impossible task, as you suggested, it would be for the state.
Well, again, there may be a difference between industry groups who know what they're doing and having consistent standards, rather than putting this before what my friend calls a jury of your peers for a different, possibly quixotic, certainly unpredictable and inconsistent result in every individual case.
Thank you, Mr. McConnell. Your time has expired.
I have a question.
Uh,
Chief Justice.
well, you know,
That's all right. I can put a vote in. It's all right.
The life of the junior justice.
Yes.
actually.
I think she's going to allow it. So I'll try it and think you let me know.
Incredibly short,
Yeah.
because we're going to have to extend Mr. Cruz's time. So if you could briefly say it, briefly answer it, we'll not.
The cutoff age is what,
18.
18. And if your representation is that under the statute as it's drawn, if the parent authorizes the purchase by the person under 18, then it may be sold. Is that correct?
That's my understanding of the statute.
Thank you so much,
But
Mr. McConnell.
is it also the case that the blanket permission, so that the under 18 person would simply carry around with them a card signed by the parent saying, my child, Susie Smith, shall be...
The statute makes no provision for that.
You say it would be consistent or not allowed by the statute?
It would not be allowed. At least the statute doesn't make provision for it.
Thank you so much. Thank you. Since we're not the real court, we do indulge each other. Okay. Mr. Cruz, you've got 5 minutes.
Thank you, Governor. I'd like to make 4 points in rebuttal. Number 1, in obscenity, the standard for adults is the strict standard of Miller. But yet for children, it's rational basis review under Ginsburg. That suggests a parallel for adults and children with respect to violence. Violence is not something unknown to the First Amendment. Adults are constrained by 2 principal limitations. 1, Chaplinsky's limitations on fighting words. And number 2, Brandenburg's limitations of incitement. Those are both very strict standards. Following the parallel to obscenity of adults and children, it suggests for minors that there is a lesser standard for restricting speech that focuses on violence. The second point I wanted to make. The position of respondents is that obscenity, sex, is somehow special and unique and the only thing that is exempt from the First Amendment. I would point out that profanity is also treated as not fully covered by the First Amendment. In 1792, when the First Amendment was ratified, all 14 states had either blasphemy or profanity as a criminal offense.
So, counsel, what about, say, gambling? I mean, that's another vice traditionally seen. Why not suppress any gambling game? Children can't go to Vegas and gamble. They can't, why not, can the state suppress any gambling-related games for the same reason?
Justice Raymond, that is right now the current state of the law, that children are not allowed to go to Vegas, and online gambling is illegal under federal statute.
And a game that simulates gambling, like, say, poker. How about that?
That would depend on the evidence. I doubt that would be permissible, but it is...
strip poker.
Mr. McConnell said the statute here is different from the statute in Ginsburg because the statute there was utterly without social importance. With respect, Mr. McConnell misquoted the statute somewhat. The statute in New York in Ginsburg said that it was material that was utterly without redeeming social importance. And that addition of the word redeeming suggests a comparison of the social importance to the harm of it. Secondly, the court in Ginsburg explicitly stated this material is not obscene. So it was material that was not obscene, but nonetheless could be prohibited to minors. The final point I want to make Respondents have spent a great deal of time essentially saying, there's not a problem here. The state hasn't done enough to demonstrate a problem. I would point out that the data Mr. McConnell relied on in this courtroom are really quite compelling that there is a problem. According to the 2010 census estimates, there are 75.2 million children in the United States. Mr. McConnell stood up here and said the most recent FTC data demonstrate 83% of kids buy video games with their parents.
That doesn't get you to your hard evidence, that's just a number.
Well, but it does get one to the obverse, that if 83% buy them with their parents, 17% don't buy them with their
But
parents.
that doesn't answer the so what question that we had in your argument, Chief.
I don't disagree, but it does answer the question of, is this a problem? Is this happening? Is this occurring that children are buying these video games and able to buy the video games? And the data that respondent is relying on demonstrate 17% of 75.2 million is 12.8 million. Now, he further said, the most recent data shows the voluntary ratings have been more successful. So 80% of the kids succeed, are stopped the first time they try to buy something. Again, the obverse obtains. That means 20% are not stopped.
What response do you have to the state's amicus brief for respondent who say, save us from statutes like this. We have law enforcement priorities, and among them is not turning our cops into nannies and checking who's buying video games with all these millions of children running around the video stores in America.
My response would be Justice Brandeis's response, that the blessings we have of living with laboratories of democracy. If states wish not to regulate that, that is their prerogative. The California legislature, acting on its interpretation of the will of the people, I would point out the California legislature, like Justice Brennan in Ginsburg, is hardly known as a bunch of crazy right-wing kooks. The California legislature concluded this was a serious problem, and it was a problem where parents' hands were tied. I would point the court to what this court said.
You've got about 2 seconds left. Does anybody else have another question?
This legislature is made up of crazy right-wing coups.
Thank you. Case is submitted. Thank you. Thanks to both advocates. That was wonderful. And what we do now, again, not like the real court, the fake court, we're going to take 10 minutes. We're going to go into our conference room, deliberate, and come back with a ruling. So during this 10 minutes, talk among yourselves. Thank you.